Good afternoon and welcome. I'm going to give a moment or two for the participants, for you all to enter our virtual doors. As you're logging in, we thank you for joining us this afternoon for the Center for City Laws and JCOPE's CLE on local lobbying and the Lobbying Act. We had a really good response and we thank you all for attending today. So we'll give it a minute or so and then we'll begin. Okay, we will get started. Good afternoon, everyone. My name is Brian Kazuba. I'm the Associate Director for the Center for New York City Law here at New York Law School. And we are happy to host today's CLE with JCOPE on local lobbying and the Lobbying Act. On behalf of Dean Anthony Crowell and Professor Ross Sandler, Director of the Center for City Law, we thank you for your attendance, and we thank JCOPE for their partnership in putting forward our fourth annual CLE together. This is our second virtual one, following a few that we did in person. We're sorry we're not able to do this in person this year, but we hope everyone is well and safe where you are, and we hope to see you in person in the near future. For everyone who is looking for CLE credit, you should have received an email already with your materials and how to submit your codes and how to submit your evaluations. Throughout the course of this panel, you will receive 3 codes. Please write them down and submit them shortly after the event. You'll get an email again right after the event to do that. Please do that. We also want to make sure that how your name is presented as you enter Zoom is your full name and not an acronym. So we're able to make sure that it syncs up with our attendance record, so we know that fact that you did attend. So with that, I will turn it over to Sanford Berlin, JCOPE Executive Director, for welcoming remarks. Sanford, thank you. Sanford, you're muted. Sorry.
Here we go. Thank you, Professor Kazuba. Welcome to everyone. On behalf of JCOPE, I want to thank Dean Crowell and his outstanding faculty and staff at the New York Law School for partnering with us for our annual CLE program. This is my first event as JCOPE's Executive Director, and I'm thoroughly impressed with how well our teams have been able to collaborate in putting together today's CLE. To Professor Ross Sandler, again, Professor Kazuba, Lillian Santiago at New York Law School, and JCOPE's team of Monica Stam, Martin Levine, Carol Quinn, Walt McClure, Megan Hennigan, and Megan Matullo. Thank you all so much for the work you've put into this. We have a tremendous panel of experienced practitioners, Nick Hockens, Stu Besson, and Steve Leventhal, and I'm really looking forward to the discussion, which will be led by JCOPE's own Carol Quinn. The intersection of lobbying regulation and land use and development activity at the local level is an important subject that deserves more attention than it generally has received. And based on the questions we've received in the past, we know there are gaps that need to be filled. So as we continue to build a more robust and comprehensive regulatory structure, it is crucial that we pause periodically to explore the gray areas, ask the hard questions, and figure out how we can best fill those gaps in an effective and fair way. In essence, this is a tremendous opportunity, not only for us to teach, but also for us to learn how to best promote compliance and transparency in government. I thank you all for attending. I thank our panelists and all the folks at New York Law School and JCOPE for the hard work they've put into this CLE. Before Carol takes over, Professor Kazuba has some important information for everyone. Thank you.
Thank you. So for those in attendance, after the panel presentation, there's going to be some Q&A. To do that, we're going to use the Q&A function on the Zoom. At any point during the presentation, you can use that Q&A function to submit a question. We ask that you identify yourself and your affiliation, ask a question, and we'll try to get through as many questions as we can using that function towards the end of the panel. At this time, I'm going to give you all the first of 3 codes that you'll need to get CLE credit. The first code is LOCK, L-O-C-K, LOCK. Okay, so with that, I will turn it over to our moderator for the panel, Carol Quinn, Deputy Director of Lobbying Guidance. Carol?
Thank you, Brian. I just want to thank everyone for coming and participating in the panel as well. As Brian mentioned, I'm Carol Quinn. I'm the Deputy Director here of Lobbying at JCOPE. I'm very excited and happy to facilitate a discussion today about local lobbying, and also with a focus on land use and how land use activities may implicate or trigger disclosure requirements under the Lobbying Act. So we decided to do the CLE about local lobbying with a focus on land use, mainly because we were concerned there was confusion at the local level about what local lobbying is, and especially in the land use context, because much of the attempts to influence activity at the land use context occurs before local boards. It occurs before local councils, local commissions. So we were concerned that there could be a significant amount of activity that constitutes lobbying that's not being properly reported. Which brings me to what I view as the lobbying unit's mission at JCOPE, which is twofold. We're all about promoting transparency about who's lobbying whom on what topic, what public officials on what topic, and how much money is being spent doing that lobbying in a year. And the second part is we want to increase awareness and educate people, in this case, the land use community, and also about local lobbying in general, about the lobbying law, the state lobbying law, and the requirements in order to improve compliance, which circles back and goes hand in hand with our mission and our goal of transparency. Because most filers want to comply, most filers will comply with requirements as long as they're made aware of them and they understand what those requirements are. So that's what I view the lobbying unit's mission at JCOPE is, doing those two things, transparency and letting people understand the lobbying law and understand how to comply. So with that in mind, we plan today to have a roundtable type discussion about local lobbying with a focus on land use, trying to focus on how and when those activities in land use intersect with the lobbying law. And our hope at the end after the CLE, at the end of this hopefully great discussion today, we'll be able to at JCOPE develop meaningful, clear guidance for the land use community, outlining what land use activities constitute lobbying and how and when to report those activities. So toward that end, just to try and give a framework for the CLE today, I'm going to take a 3-pronged approach to, as moderator, as best I can to guide the discussion. And so my goal here in moderating is try to teach the land use community about the lobbying law, and then to teach the lobbying community about land use, what actions or steps are typically taken to obtain a result in land use. And we at JCOPE are also interested in learning more about that today. And then at the end, I'm hoping to try to bring the two together so that we're all, including JCOPE, better informed on the implications, potential implications of the lobbying law on local lobbying level and on land use activities, and how we at JCOPE can best regulate this activity in an effective, intelligent way with the eye towards maximizing transparency for the public to know who's lobbying who on what, and minimizing the administrative burden on the regulated community. So as Brian mentioned, there'll be a question and answer at the end. Feel free to send in questions as we go, and we'll try to get to as many as we can. And I'll also mention that we do have an Attorney of the Day program at JCOPE. You're always encouraged to call us and ask us any questions that might be more detailed than we can get to today. Feel free to always give us a call. We're happy to help. That's part of our mission. Now, before I get into the Lobbying Act and what constitutes lobbying, I want to pause here and bring the panelists in, let them introduce themselves, describe what areas of law they practice in, and, focusing on, their practices, either in land use or before local governments or in lobbying, that might be relevant to today's discussion. So, Steve, why don't I hand it to you first to introduce yourself, and then maybe we can go to Nick and then Stuart.
Well, thank you. Hello, everyone. I'm Steve Leventhal. Our bios are attached to the materials, but I am a partner at a small general practice firm in Roslyn, New York, Leventhal, Mullaney, and Blinkoff. I do quite a bit of work in the area of local government ethics, and I represent numerous local municipal ethics boards and do quite a bit of public speaking on government ethics issues. Our practice also includes representing local municipalities. We're village attorneys for several villages and provide counsel to other local municipal ethics boards and land use boards in particular, zoning boards, planning boards, and so forth. So very happy to be here, and thank you for the opportunity to introduce myself.
Hi, everybody. My name is Nick Hawkins. I'm a partner at Greenberg, Traurig in New York City. I practice land use and zoning, and our practice here focuses only on the 5 boroughs within the city of New York. As we'll talk about a little bit later, the way that land use and zoning are regulated in New York City is very different from the rest of the state. So we focus exclusively on New York, and I represent developers and lenders and property owners, seeking discretionary approvals from the City Planning Commission, Landmarks Preservation Commission, Board of Standards and Appeals. A big part of our practice is helping clients understand what they're allowed to do as of right under zoning. And also I do a lot of work with development rights, sales and purchases.
Good afternoon, everybody. My name is Stuart Besson. I'm a partner with the law firm of Milber, Makris, Plousadis, and Seiden. My practice is primarily representing villages, towns, counties throughout Long Island and pretty much upstate New York, anywhere but New York City for the most part. I represent a planning board, zoning boards, and I also have the unique perspective of being on the other side. I was a former councilman in a town in Long Island. And so I've kind of seen both sides of it. And I look forward to a wonderful seminar and discussion today.
Great, thank you all again for participating. So now I'm going to try to talk about the Lobbying Act a little bit and kind of give a lobbying 101, so to speak. So the Lobbying Act is all about transparency in government decision-making through disclosing what lobbying activities you engaged in and how much money you spent doing it. But it's really important to understand that not everything is lobbying. Especially, some of the localities that might be listening today, not everything you do is lobbying. So, and that's important to understand. So to constitute reportable lobbying under the state law, and when I mean reportable lobbying, I mean, this is when you have to report it to JCOPE. You need 2 things. One is to engage in a 1cc activity. And I'm going to refer to 1cc activity a lot. It's shorthand for the Lobbying Act section 1-CC, which is really the definition of lobbying, and it includes an attempt to influence a bunch of activities, but they're specific activities. So you have to engage in one of those activities. And then doing that, you have to spend over $5,000 a year doing that. That $5,000 threshold is key. It's cumulative across all of your lobbying activity in a year. but it is a threshold you have to meet. And if you don't get over the 5,000, then even though you might have engaged in a lobbying activity under 1cc, it doesn't trigger reporting to us at JCOPE unless you hit that threshold. And so the $5,000 threshold, it includes compensation and expenses. So compensation is self-explanatory, but at expenses, you might be wondering, what kind of expenses could I have, especially in land use? And so an example I have for that is, perhaps a developer plans a meeting with, down in New York City, a city council member about their development project. They have this big project they want, this big building they want to build, or whatever it is that they want. And so they might have a meeting at some point with a council member. And in so doing, they might bring their architect, or they might bring their consultant with them at the meeting. And the architect, the consultant might be just giving technical information and be there kind of like for facts. The developer might be actually doing the lobbying, asking the city council member to, be in favor of a zoning change for whatever reason that they have. So the cost of the developer paying the architect's time or paying the consultant's time to attend that meeting, that could be a lobbying expense, because expenses have to always go back to a 1cc activity. So it's not every expense, it's just an expense that's connected to a lobbying activity. Another expense that's typical you might see would be a media campaign. There might be an opposition campaign out there. They might have some type of billboards across some locality or the city about a lobbying topic. And so you might have expenses there. Now, to get into like what is a 1cc activity, what is a lobbying activity, I want to start first with what is included in that. And again, this is a defined term in the law. It doesn't include everything. It only includes attempts to influence specific actions. So, and that includes at the state level, attempts to influence legislation. I think everyone can kind of picture the state lobbying, if you're trying to lobby and get a bill passed at the legislature. But it's attempts to influence at the state level legislation, executive orders, rate-making procedures, procurements. It includes also for state agencies if they have attempts to influence adoption or rejection of a rule or regulation having the force and effect of a rule or regulation by a state agency. So that's at the state level. There's two components to the definition in lobbying. At the local level, lobbying includes attempts to influence similar type things, laws, these are local laws, local ordinances, resolutions, executive orders, rate makings by a municipality or a subdivision of a municipality. It also includes the adoption or rejection of any rule, regulation, or resolution having the force and effect of a local law, ordinance, resolution, or regulation. So that's kind of what is included in the bucket of what is lobbying. But just as important is what's not included. So the Lobbying Act excludes certain things from the definition of lobbying, and some relevant exceptions or exclusions that may relate to land use include participation in adjudicatory proceedings, public proceedings, participation as witnesses in a public proceeding, which are part of a public record, responses to requests for information from public officials, at the state or local level, applications for licenses, certificates, or permits authorized by state or local laws. That's specifically excluded from the definition of lobbying. So that's kind of the basics of what is and what isn't. But for purposes of today's discussion, I'm going to focus on three provisions within the definition of lobbying. And so it's section 1cc, Romanet 1, Romanet 7, and Romanet 9. Romanet 1 it relates to lobbying state public officials. And so it provides that lobbying includes attempts to influence the passage or defeat of a law. And then back in 2011, the legislature added clarifying language. What does passage and defeat mean? So it says now, the passage or defeat of any legislation or resolution by the legislature, including but not limited to the introduction or intended introduction of the bill or resolution. That's a key point there. Now, Romanet 7, which relates to lobbying local public officials, it refers to the same type of thing about passage or defeat of any local law or local resolution, local regulation. But it did not, in 2011, the legislature did not put the same clarifying language in there that would say that passage or defeat also includes the introduction of a local law, for example. That's found in the state section. So that's kind of a key difference that we wrestle with. So, and another provision that we do focus on for local lobbying is Romanet 9. And that talks about attempting to influence the adoption or rejection of any rule, regulation, resolution having the force and effect of a local law, ordinance, or resolution. And so in land use, I focus a lot on the term resolution because a lot of things happen in land use by resolution. So in any event, we do focus on 1, 7, and 9 in the definitions. And that's what I'm focusing on today when I think about local lobbying and when I think about land use. So like I mentioned here at JCOPE, we do wrestle with the definition of lobbying as it relates to local lobbying and state lobbying. Did the legislature intend to make a difference when it clarified the state section, but not the local section? So when it clarified that attempting to influence the passage or defeat of a state bill includes trying to get it introduced or intending to get it introduced. But when they didn't put it in the local section, was that intentional? Or it could have been a 2 a.m. drafting mistake, completely overlooked at the time, and there's no legislative history. So we just don't know. We're stuck with it is as written. So we think about that. Or perhaps you can look at it like the plain reading of the statute covers land use activities that we'll likely talk about today. And by that, I mean, does the language in Romanet 9 regarding adoption or rejection of any resolution having the force and effect of a local law or resolution, does that capture pretty much, for example, the entire ULURP process in New York City, since much of that process is conducted through resolutions of different municipal bodies? And again, I want to talk to the panelists about that and understand better how land use activities, how you get the result you want for land use and how that's done, what's the mechanics behind that. So I think ULURP, which is the Uniform Land Use Procedure that is pretty detailed in New York City, it's a great example of that we can kind of use today as to illustrate the challenges that we have in regulating land use at the local level. But I'm hoping that the same policy that might apply to a bigger locality like New York City with a robust land use community and lots of procedures that are very specific, I'm hoping that can translate across localities. So at this point, I want to try to bring the panelists in with a couple of questions. And Steve, I'm going to start with you on this one. We're aware, I just talked about the lobbying definition and what we focus on here at JCOPE and the differences in between state and local lobbying. And so we all know the differences with statutory construction. We're aware of how to interpret a statute, but I'm really kind of wondering what the policy rationale could be here. Knowing government like as you do, is there any reason you can think of why state and local laws would be treated differently in the lobbying context? So is there any reason why there was a clarification on the state part, but not the local part? And is there any reason why passage or defeat of a bill would include trying to get it introduced at the state level, but not include it at the local level?
Well, it seems to me that the validity of a regulation should be measured by how effectively it achieves a legitimate purpose. The declared purpose of the lobbying law is to preserve and maintain the integrity of government decision-making by requiring public disclosure of the identity of expenditures, the activities of persons and organizations paid to influence legislation, rulemaking, and regulation. if the purpose of lobbying regulation is to reduce the potentially corrupting influence of money in government, then the regulation should go where the money is. In New York State, perhaps uniquely, one size does not fit all. Nassau County, the county in which I reside, has a population in excess of 1.3 million. The county of Hamilton has a population of approximately 4,400. There are over 400 towns and villages with populations of less than 1,000 and 30 towns with populations of less than 250. There is a state law for local municipalities, Article 18 of the New York General Municipal Law, that regulates the solicitation and acceptance of gifts by local municipal officers and employees. That statute includes a financial disclosure requirement for municipal officers and employees that applies only in municipalities having populations in excess of 50,000. So in that case, the legislature has made policy determination that distinguishes between disclosure requirements that are appropriate for more populous municipalities and those that are appropriate for municipalities that are less populous. And insofar as the manner in which legislation is introduced on the local level, in the world of smaller municipalities, which is primarily the world in which I practice, there is more informality. And there is, however, an aging requirement for laws adopted by local municipalities. The Home Rule Law, the New York Home Rule Law, requires that proposed legislation be, the statute uses the concept of on the legislator's desk, which is in this virtual world is a little bit of a misnomer. But there is a requirement that the legislature, that the proposed legislation be distributed to the members of the body a certain number of days in advance of the meeting at which it's going to be considered. There's also requirements under the Open Meetings Law and the Freedom of Information Law for meeting agendas to be prepared in advance, for public notices to be published, and for documents to be available for public inspection and copying in advance of the meetings. So there is that period of time, that gestation period for local legislation, when it is not yet proposed or not yet introduced, but proposed for introduction.
Right. So one thing I do want to point out is the Lobbying Act does define municipality. It used to only refer to lobbying before a municipality that had a population of 50,000. It went down to 5. So it actually does include most counties in the state. It might be, Hamilton comes to mind. That might be the one county in the state that doesn't get captured with the $5,000 population. So the legislature clearly intended at that point to capture more local lobbying when it made that change. So, that's interesting. I think what I'm focusing on here today is, and what Steve was just alluding to, it's difficult to, I think what Steve mentioned is important, because the Lobbying Act is definitely about transparency. So if you're going to say that, let's take land use aside, if you're just trying to get a local law passed, does it mean that until it's on an agenda or until it's like actually written and before the local legislature, that everything that happened before that is not lobbying? It doesn't include all the work that gets done to get it there. I don't know if Nick or Stuart have anything to add about this.
Yeah, I would like to just, I think what Steve said is true on a local level outside of New York City. The process is much less formal. It's a very informal process. And it's more of a process where constituents and local civic associations try to influence or try to shape a local law. Money plays little to no role with regard to that. So, you could use the million examples, but just one example would be, we just recently had in one of my local municipalities an issue with curbing leaf blowers. And there were local landscapers that were very much against that. Now, they did speak about that at the public hearing. They may have had conversations with local trustees, the local mayor beforehand, but there really was no issue with regard to the $5,000, and there was no money involved. There was nothing like that. It's more of an informal process. It's more of, let's have a cup of coffee, or let me meet with you and tell you why this local law is good or why this local law is no good. So that's why I think why the requirements from the state perspective is much more regulated and more broad when it says introduction or intended introduction versus towns outside of New York City or New York State, the local level, why the legislature made the distinction. And I think it's a necessary distinction, an important distinction, because it's done completely different, and money's really not the crux of the lobbying in local towns and villages.
Yeah, I would agree on that. And also the $5,000 threshold, I think, does carve out a lot of these informal conversations that could equate to the definition of lobbying. But since no money really is being spent, you can look at that from that perspective as well. So like looking at New York City, for example, they have lobbying, definition of lobbying, and their the local law there versus the state definition. And so there's differences. And so we, the people that practice in New York City have to report to New York City and report to JCOPE, assuming they meet the threshold here. And, one of the differences is New York City's local law actually really is specific to land use, where the state law is about all local lobbying. So it doesn't distinguish between land use versus, trying to get a local law passed. And so one of the, New York City is really specific about that. And so I'm wondering, if any of you can speak to the challenges of trying to comply with both, because as Stuart says, some of the smaller towns and villages, you're not going to have reporting because they're not going to hit the threshold, for example. So there won't be reporting for that. But for someone that practices in New York City or some of the bigger counties on Long Island, I'm wondering I'm assuming there's challenges trying to figure out where to report and how to report. And I'm wondering if any of you understand even where the line is in New York City, for example. Where's the line of where lobbying is, and when do I have to start paying attention to reporting to New York City? And if you even know where the line is, which is part of why we're here today, to try and get information and make a policy judgment, hopefully after. But where is the line? I'm wondering if any of you see where the line is, and also even would you appreciate, assuming within the law that could there be any, wouldn't it be great to have a common set of policy, common set of requirements across jurisdictions? So I don't know if anyone wants to tackle that.
I can't tackle necessarily New York City, but I would argue the opposite, and I think Steve did a good job discussing that. I don't think, one size fits all in this situation. There is a tremendous difference between land use and lobbying in New York City, which I know Nick can discuss, versus land use and lobbying in towns and villages in the suburbs and upstate. It's completely different, and it would be impossible to have one set of rules for all, and that's my opinion.
Carol, I'd like to add something. You spoke about the $5,000 threshold, and on its face, $5,000 seems to serve the purpose of exempting more casual and activities that involve less money. But you also mentioned that that's a cumulative threshold over all lobbying activities. So that pulls back in many small transactions that perhaps are not so likely to have a corrupting influence on the government decision-making process as to require compliance with a regulatory system that may not be burdensome to large lobbying entities practicing on the state level, but may be very burdensome to smaller consultants like the architect that you described in your introduction, who may be paid by many different clients to attend many different meetings, or the developer, I should say, who frequently pays architects and engineers to attend meetings with government. Small payments cumulatively can easily reach $5,000.
That's absolutely true. You are correct. It is cumulative, and that's just basically not just in land use. It's for any lobbyist. And we don't look at we look at the activity. We don't look at the person or the entity that's doing it. We look at the activity, and is the activity a lobbying activity? And if it is, does that entity, and usually the entity, the lobbyist is usually an entity. It's not usually it can be one person, but often it's a company, like in this case, it could be the developer. So you're right, it can capture, you can hit the over 5,000 in a year, and it would capture, and that's probably why, that's definitely why we're trying to, we want to maximize transparency when there's lobbying activity. But we want to minimize the burden on people. So part of this discussion today is to try and find out how land use works, what's involved in it, and to try to apply the definition of lobbying to the land use context. So I understand we're trying to regulate the Lobbying Act in a meaningful way that's not burdensome. That's not what we want it to be clear. And so I don't want to scare people today to think everything, certainly an architect, the architect's not the lobbyist. The architect is just going to the meeting. Right. So I don't want to scare people about that. And of course, I encourage people to call us up after this. And we're going to take all this information and learn from it ourselves, because it's hard to understand how to regulate lobbying in all contexts, right? So especially the land use context, which is, pretty particular. And as Stuart said, completely different in New York City or a bigger locality compared to a smaller county, completely different. So before we get into land use, and I'm going to turn to Nick soon about that, but before the last thing I just wanted to ask about is what everyone's thoughts are on when, I'm trying to figure out if you had just a regular local law, maybe the leaf blowing, or maybe a locality wants to limit the use of plastic bags, and they want retailers to stop using plastic bags. And, the grocery stores have done that. So maybe that's a local law that a municipality is considering. And maybe you have a client that's opposed to that. You might have, for whatever reason, they're opposed to it and wants your assistance. And I'm just wondering, and again, this is just a regular local law that a municipality is considering. Where do you think, and when would you try to influence that? Would you wait for it to be on the local legislatures, councils, whatever it's called, agenda? Would you wait until it actually gets there? Or would you try to talk to the mayor's office or talk to the local legislator well before that? I'm trying to focus, our attention a little bit on when advocacy happens, just to understand and then try to apply it again to the definition. So I don't know if anyone can speak to that, about where you think you'd start. Would you wait for it to be on the agenda, or would you try to meet with people well before it gets there?
So I think there's a two-part answer to that. I think under the law, from a local perspective, it's when you schedule the public hearing. That's when you're really introducing the proposed law to the public. But in reality, a lot of times it's the other way, where the government official is reaching out. Let's use the leaf blowers because it's a good example, where the local officials might reach out to the local landscapers and say, look, we're looking to ban it on Sundays, or maybe half-day Saturdays, or what do you think? So the lobbying isn't that the landscapers in this scenario are reaching out and trying to lobby the local government officials. It's the local government officials are reaching out to the people that it's going to affect, including the homeowners, and saying, before we draft this proposed law, let's learn about it. But from a lobbying perspective, I think on a local level, it's when it's drafted and it's introduced to the public, that's when the lobbying can or may begin. The other is just informational and you don't even have a local law drafted. You're just trying to get information from people that it may or may not affect.
I think that there are some instances, as Stuart says, where mostly for political reasons, the local elected official, usually the mayor or whoever the chief executive is, will reach out to, or perhaps members of the governing body will reach out to members of the public to solicit their views. But that's the rare case. In most instances, there'll be a telephone call or a meeting between the mayor, if it's a village, and the municipal attorney, or the supervisor's office and the town attorney's office. And they will plan some sort of legislation that won't be on anyone else's radar screen until it's there's a publication or a hearing scheduled, as Stuart describes. That's the way most local legislation occurs. Now, again, it's impossible to generalize here, because there are many municipalities to which that process is, would not apply. It's very different. It's more elaborate and more layered. But that's mostly in the more populous, larger municipalities.
Right.
Which are the minority. Which are the minority of municipalities in the state of New York.
Sure. Right. No, many of the counties are much smaller, and New York City is huge. When I say huge, takes up a lot of attention with and it is so different with lobbying than your small town in Western New York. All right, at this point, I just want to switch over maybe to land use a little bit. I want to get into I want to walk through, and I'm going to lean on Nick Hawkins, who is the subject matter expert in land use on our panel today. And just wondering if Nick, you could walk us through, there are a bunch of transactions that are typical. A zoning change comes to mind. You might want to there might be a landmark designation, there could be permits, subdivision approvals, developmental rights, a variety of activities. And I'm wondering, Nick, if you could just kind of walk us through what these things are, just so that we all have a grasp of that. You are on mute.
There we go. Thanks. Sure. So let's start with permits. And again, I'm going to be speaking about zoning actions within the city of New York, which is different from other municipalities. But in New York City, we have what's called as of right zoning. The zoning resolution of the city of New York maps residential, commercial, manufacturing zoning districts over the entire city, except for streets and parks, and sets regulations that apply, regulating use, bulk, parking, loading, and other factors for each of those districts. So when you have a project, if that project complies with the zoning requirements for the district in which the project site is located, then you go straight to the Department of Buildings and you show them with your zoning drawings that you comply, and there's no planning board approval. Nobody gets to comment on whether they like the facade that you're using or how it fits in with the context of the neighborhood. It's a completely ministerial process. And DOB under the city charter, they have the authority to interpret the zoning resolution. So, the zoning resolution, it's, I think, over 3,000 pages, but even with that, it can't cover every possible scenario. So you can go to the DOB, you can say, I'm reading this text and I'm applying it to my situation, and I think this is how it applies, and get a determination from them. And they can do that, but they can't vary the zoning resolution. They can't grant a variance. They can't say, well, you're right, 100 feet isn't tall enough for your project, take another 10. To do that, you have to go to the Board of Standards and Appeals, or you have to go to the City Planning Commission. So that's permits. For zoning changes, those are handled by the City Planning Commission generally. The Board of Standards and Appeals grants variances, and there's a few special permits under the zoning resolution that the BSA is responsible for, but generally it's the City Planning Commission, and they are the entity that adopts amendments to the zoning resolution and changes to the map. So when we talk about a rezoning, when a project is when an area is being changed from a residential district to a residential district with commercial use allowed, that goes through the City Planning Commission. City Planning Commission also grants certifications to show compliance with very technical requirements that apply in certain cases in the zoning in the city of New York. They grant authorizations and they grant special permits. And those are all, except for the certification, those are all discretionary approvals. They require environmental analysis under seeker, and they are subject to the Uniform Land Use Review procedure or other similar procedures that are set forth in the zoning resolution. And so that after it goes this, that process, it starts with a meeting with city planning, an informational meeting with the borough office, and you provide them some materials in advance, and you say, I have a client that they control this site. They want to, the zoning allows 150-foot tall building, and we want to rezone it, or we want to get a special permit, or we want to do something else to do this instead. And the staff will discuss with you, their read of the likelihood of that project being successful and moving forward. If we get clients who come in and say, I want to put a Ferris wheel inside Central Park, and we can tell them like this is just not going to happen. Or we're in an R1 or R2 low density residential district, and we want to upzone it 10 times. I mean, and we, those are ones that we're pretty good at weeding out. But sometimes city planning has other ideas about what's appropriate for this area. Like there's a lot of, there are manufacturing districts that city planning is now kind of holding. They don't want to rezone because there's a limited amount of that type of use left. So that's the kind of thing that might turn up at the informational meeting. But if it goes well and they say, yes, we think that's something that's good, then they might say, before we move forward though, you need to go check the temperature with the community board and or the council member and see whether this is something they're going to support. Assuming everybody initially is open to it, then you start the formal, the formal process with the Department of City Planning of making the application, doing the environmental analysis, the land use written materials, the drawings, and that process can take a really long time, anywhere from 8 months to 2 or 3 years, depending how complex it is, whether or not an environmental impact statement is necessary. But at a certain point, the city planning staff are satisfied that the application materials are complete, that the environmental analysis is complete, and then the City Planning Commission certifies the application to start the formal public review process that's set out in the city charter. And that begins with 60 days at the community board. Community board will hold a hearing, public hearing, and then they will vote on a recommendation to approve or disapprove or modify. It's non-binding, but half of the community board is appointed by the borough president, the other half's appointed by the council member. So the BP, the council member, city planning take the recommendations very seriously. And you get a no vote, like an overwhelming no vote, you got a problem. Then it goes to borough president for 30 days. He or she can also hold a hearing. They usually do. They do a non-binding recommendation. Then it goes to City Planning Commission. They have 60 days. They hold a hearing and then typically vote 4 weeks later. And if they vote to approve, then most items go automatically to the council. Some the council has the discretion to decide whether to call up or not, like a special permit and authorizations. They typically can make a decision whether to call it up or not. And the council member, the council, again, will hold hearings and almost always defers to the local council member in terms of making the decision. So that's really the person that you're primarily focused on.
Okay, so I'm wondering, I understand there seems to be a lot of discussion well before you even apply and submit an application to the Department of City Planning, trying to take their temperature almost like, is it worth anyone's time to even proceed? But then you get through all of the procedure that you were just referring to, and it seems like it can take different approaches depending. What's the mechanics of it? You're saying, and I just want to understand, so if you have a community board or you have the borough president and they're making, I think you called them recommendations to like approve, or what's the mechanism for that? Do they just, is there a resolution that they vote on?
Yes, it's very formalized. So after you're certified, you've begun ULER. When you go to the community board. The community board, all the community boards have land use committees. So first you go to the land use committee and you present your project at a public hearing, I guess. And you know, the board, the committee members will ask you questions, and you'll respond. Oftentimes they open it up to the people in the audience from the public to ask questions also. Sometimes they don't. It just depends. But it's a published, noticed hearing. And usually they'll vote at that meeting to vote on a resolution. So they may say, you know, we're going to approve this subject to these conditions. We're going to recommend approval provided that you take 10 feet off the top of the building, that you build a park over here, that you do this, that you do that, right? And then you come back in a couple of weeks and it moves from the committee to the full board. And depending on the community board, sometimes the committee chair will just give a report, and there'll be a vote, or sometimes they'll want you to re-present to the full board and there'll be discussion and a vote. It just depends. And then yes, the committee has drafted a resolution, the board has voted on the resolution, and then the resolution is filed with the borough president and the city planning commission and the city council, and it becomes part of the public record.
Okay,
And then the number of people who opposed, for, abstaining.
right. So, okay. And I know the New York City process is much more involved and much more formal than something going on that like the leaf blowers that Stuart
Right.
was mentioning. So, and we understand that. But I am interested in hearing from New York City, because that is something that, you know, we at JCOPE have to try to apply the Lobbying Act to all, but it is so different in the land use. So it very well might be differently applied depending on the mechanism of how a land use project or activity or transaction can go from A to B. And in New York City, it sounds like a lot of it is done by resolution. Now, I don't know. So it seems like when I look at the Euler chart, and I am so not an expert in it, which is why I have you on the panel, but I wonder about that Romanet 9, for example, in the Lobbying Act about the definition. And so do these resolutions before the city planning, before you get to the city planning commission, or after, you know, and I'm not saying that you would necessarily have the answer, but I'm just, I think about that, because does a resolution that need, you know, these are required steps in New York City that you need to go through. And if you don't, you're not going to get to the end result. And you're not going to ever get to the city council, or you're never going to get to the city planning commission if you don't go through these required steps. And
Right.
so that, you know, that might be different. I mean, how do we think about that compared to, you know, if they're required steps and they're done by resolution? Does that implicate Romanet 9 of the lobbying, definition of lobbying? Or is it when you get to the city planning commission level, perhaps their resolution has the force and effect of law? The city council may or may not take it up. You know, there are so many nuances to that. But I'm always trying to get it back to what's the definition of lobbying, and how can I apply that? How can we at JCOPE apply that in a way that makes sense? You know, and it is very different between what you're describing, which is very formal, and those steps are required, versus what Stuart describes. So, you know, I think about that as, and I wonder from your perspective, and now I'm going to try to get land lobbying and land use and try to connect it a little bit here. I'm wondering, Nick, where do you think a project in New York City, for example, can sink or swim?
every step of the way, right?
Yeah.
But no, really, so I mean, in terms of lobbying, state lobbying, right? I mean, until you're finished with the city planning commission and the council and the application has gone to the council, or the council has elected in a couple of cases to pull it up. I mean, there's always a real significant possibility that that the project will not move forward, right? Like as I mentioned, the community board, the BP, those are both, they're non-binding recommendations, you know, and I mean, until the city planning commission acts, nothing is set. It could go back. It's rare, I mean, because you don't normally start that public review process. I mean, you don't normally start the public review process if you think you're going to have big problems at the council, really, right? But it can happen. I mean, nothing is guaranteed, at least until you get through city planning.
Okay,
Carol, can I ask a question related to the definition of lobbying in the land use context? One of the exclusions that you mentioned was applications for licensing, certificates, and permits authorized by state and local law. Virtually every land use application that I've ever encountered had as its ultimate goal the issuance of a permit or a certificate of occupancy, certificate of completion. If you apply for the building department for a building permit and the application is denied, and you appeal that denial to the zoning board of appeals, is that still part of the process of applying for a permit that is excluded from the definition of lobbying? Or if you're referred to the planning board, or you need to go to the planning commission of the county because of the location of the site, all of these are steps in the path toward the issuance or denial of a permit. Are those activities to which the lobbying law would apply?
right, so the lobbying law does specifically, the one part that's at all specific that you might apply to land use is the application for permits or licenses authorized by state or local law. So you're correct, but you know, a zoning change, you're changing the law, you know, so there are differences within land use.
Right.
You know, and so, yeah, I mean, all of these things come into play. They're all the type of things that we think about here.
Right,
and-
a zoning change is legislation, but the grant of a variance is an administrative act by the zoning board.
Correct. And these are the things that we're having a discussion today about. You're correct, a variance, you're asking for a special permit, for example. You know, we're looking at all of that in the land use context, and using today's discussion to really think about what, you know, the definition of lobbying means in the land use context, and trying to understand even the different procedures that might apply in New York City versus a smaller county, and the differences. And you're right. I mean, these are the things that we look at all the time. I think we're running a little bit close to time. I have one other thing I wanted to present to you all. Just checking the time here. So Nick, thank you so much for going through all of the land use and how that works in New York City. And Stuart has mentioned how it's worked more at a local level, and how, you know, a local law might come really from the mayor, and they might be asking the landscapers. There's a variety of things, and in the bigger localities, it might be a developer that's trying to get something done, and the smaller communities, you're right, it could be coming from a mayor's office about something. But so when we're thinking about when the Lobbying Act gets triggered, the one concern that I have, and this could lead to a kind of a perverse result, is if the line is where a local law or resolution is actually on the agenda before the local legislature, whether that's New York City or Albany or somewhere. all of the activity, so in land use context, if a development project gets killed before it ever reaches the city council in New York City or the city planning commission, or before it reaches any law reaches the local legislature, there'd be no reporting by anyone, no reporting by the developer trying to get the project completed, no reporting by the opponents to it. I'm sure we can all think of examples of opposition to land use. And there are campaigns on that, and there would be no reporting on that either, because it either, if it gets killed before it gets there. And I wonder about that, because the goal of the Lobbying Act is to talk about transparency. And so if something gets killed or prevented from happening, then there's no reporting by anyone at all. And I'm wondering what you all might think of that. As we're trying to regulate lobbying, promote transparency, have clear lines so people can comply. And also just thinking about the definition and the policy rationale. And that's something that concerns me. If we have the line at, it has to be on the agenda at the local level. And then anything that happened to make sure it didn't get there by both sides would not be reported.
It's not going to get there. It's going to be killed before it reaches any type of legislation, or if it's a land use zoning change. I think that you have to look at, again, the $5,000, that trigger. It's probably being killed. And I think it would be probably similar to New York City, but I'll let Nick speak about that. But on a local level, it's being killed because there's tremendous community opposition to it. And the legislator or the village trustee or the town board, they're feeling that there's just no motivation to do this. There's just a lot of opposition. My constituents are against this. The local civic associations are against this. So this is never going to see the light of day. It's not going to happen. But I don't know it's going to be classified, quote, under the lobbying law, because it's not about money. There is no money. It's just about, quite frankly, getting reelected. It's about votes.
Also, you're interested in the integrity in the government decision-making process, not in the political process.
Right.
If there's sufficient opposition for something never to come before a government board, then it has been, it is the victim of politics, not the victim of improper government decision-making.
Right, correct. What we're trying to do today, and I don't know if we need to get to questions soon, but we're trying to apply the Lobbying Act to local lobbying in general. And what does that mean? Looking at the statute, does that difference that I described at the beginning of the CLE, is that how do we interpret that? Talking about land use and hearing the differences between New York City and what Stuart and Steve are talking about, there's such, New York State is so vast, there are so different, localities are so different. That, and the lobbying law does have the $5,000 threshold, which does prevent, shouldn't say prevent, but it excludes, carves out lobbying activity that doesn't, cost any money. And, yes, there are the mayors might want to, there might be politics involved in a decision. True. We're interested in making sure that if there is a lobbying campaign, and, this might not happen at the smaller local level, but certainly could happen in New York City if there's, a bunch of billboards around asking everyone to contact their local officials, contact the mayor, let's kill this development. let's make sure the city council votes this down. Those things that we do want the public to know about. And so we're trying to, again, kind of maximize that transparency that the Lobbying Act calls for, but minimize the regulatory burden and try to make sure, and part of today, the result of today, what we hope, and I mentioned this at the beginning, is we hope to have, after discussing this, and I might call you all back after this, have more discussions, try to come up with some clear guidance on how to apply the Lobbying Act to land use, to local lobbying, and try to provide some clear guidance that, it's not a huge regulatory burden, but also maximizes the transparency. And that's kind of the balance that we're always looking for. And we're dealing with the Lobbying Act as written. So, today's discussion is really helpful to me and to those of us at JCOPE to kind of understand the differences, across the state, to understand, how things work. And not everything, again, is lobbying. Some of the results are political decisions by a mayor who wants to get reelected, and that happens. And there's, it has nothing to do with lobbying. No one asked the mayor to do something or not. It's not lobbying. Like I said, not everything is. So we're hoping to come up with some clear guidance. We're thinking about this. We're looking into the definitions. We're looking into how land use works in New York City versus a smaller county, and trying to figure out the mechanisms too. How's the EULA process work? It sounds like there's resolution throughout the process. Well, does that mean it's lobbying, or is there another trigger point that makes sense to make something lobbying? Because in New York City, a lot of times the developers are spending more than $5,000. So, all right, with that, I think we should probably switch over to the questions and answers, because I think we've run a little long.
Thank you, Carol. First, we're going to give our second code. We gave the first code earlier. Our second code is PRIME, P-R-I-M-E, PRIME. That's our second of 3 CLE codes. So we have about 10 minutes left, and we'll get to as many questions as we can. We got a lot of great questions. If we do not get to them, the beauty of the fact that we're on Zoom is we'll be able to submit all these questions afterwards to JCOPE and the panelists. So, they can possibly respond to you or do something with these questions, but your questions will be heard, even though if they're not answered here today. Our first question is coming from Lauren George, and she's singling out you, Nick. She wants to know, when do you advise clients to begin reporting activity before EULA certification? How much time before certification?
Well, I'm a land use attorney. We have a whole team of lawyers in our government practice who help us make those decisions with respect to when to register for lobbying, and it differs between New York City lobbying and New York State lobbying. So it's really something that you've got to discuss with an expert, and I'm a land use expert, but not a lobbying expert.
Okay. Next question is coming from Ray Sanchez. In New York City, is facilitating the acquisition of letters of support from elected officials for proposal as of right project covered activity under the lobbying laws?
So I don't know if that's really a question for me, but I'm going to have to just ask Nick to explain the background to that question before I can answer it.
I mean, I think what's being asked is say you had an as of right project, and I don't know, and I don't know why you would be trying to generate support for that, because really the Department of Buildings doesn't. There's no discretion. I mean, if you meet the requirements, they have to issue a permit. I mean, that's just the way that it is. But so I don't quite see. I don't quite see why you would be lobbying, or I don't quite see it. If you were, but let's just spin it a little bit. Let's say that you're going for a discretionary approval. You've got your your affected council member that you're dealing with, and you're seeking letters of recommendations from other people who aren't part of the formal ULURP process. You want to get the other borough presidents to say, this is really important. You want to get the other council members to write letters saying this is really important. Would that be lobbying?
Okay, so that sounds more like it's grassroots lobbying. So, you know, I always fall back on it has to be a 1cc activity. So you have to be asking to get a law passed, a resolution passed, or something along those lines. That's kind of the generic answer, right? So you have to be asking to have that done. If you are soliciting support from the public to contact their local council member, or even if you're suggesting you want an elected official to contact, you know, a different elected official to support, you know, something, but it has to be all of those things. It has to be a grassroots lobbying communication. It has to be, you know, you're seeking support, you're asking another person to contact a local public official to do something that's lobbying. And if those things all come into play, you know, it's hard to talk in hypotheticals, but if those things all come into play, that would be lobbying. Whereas I think what Nick was talking about, the as of right, that doesn't sound to me like it would be lobbying.
I think it's at this point with that question, at least it's important to point out, and I know Steve could further go into this, it's not about lobbying. It would be unethical for elected officials in a town or a village to put in a letter of recommendation to the local zoning board, planning board, or anything like that to try to influence a variance or a subdivision or a site plan. They're supposed, at least on Long Island, they're independent bodies, the zoning board and planning board, and they shouldn't even go to the zoning board hearings and the planning board hearings, the local officials. So not only should, I don't know whether you call that lobbying or not, it's just completely inappropriate, at least on Long Island. And I don't want to speak about New York City, but it would be the only role that a council person or a village trustee or a mayor or a supervisor has is the appointment of planning board members and zoning board members. They are not there to influence their decisions in any way whatsoever.
Okay, we'll move on to our next question. This is coming from Michael Miola. Other consultants, financial consultants, for example, may also be situated similarly to architects and engineers, reporting facts and not trying to sway decisions. Is that considered lobbying?
Okay, so I can take that. So the short answer is probably not, no, because I'll hearken it back to, it's not who you are, it's what is your activity. And if your activity as a financial consultant, it doesn't sound to me with the way the question's phrased that financial consultant is actually engaging in a lobbying activity, because they are simply perhaps meeting with a public official to give technical information, financial information. They're not trying to attempt to influence a lobbying activity. They're really just providing technical information, which is very similar to the architect. So, you know, like I said before, a developer, and this could be anything. So it could be any meeting. It doesn't have to be land use. If you have, you know, a company that goes in and tries to get a local law passed or a state law passed, they might bring in some specialists. It could be a financial consultant. It could be any type of consultant. That consultant is not a lobbyist. That consultant is just providing information. Now, the time that consultant, you know, that who want the meeting with the public official, and I bring my consultant with me, whether it's financial, an architect, anything like that, I'm paying that person to come. And so that time counts against my $5,000 threshold, and whether because I'm the one that might be the lobbyist in that situation. The financial consultant, the architect, just again, I just harken back to what are they doing? Are they engaging in a 1cc activity, a lobbying activity? And the way the question was phrased, I would say they are not.
Great. We'll do a couple more questions. Next question is coming in from George Haggerty. Can lobbying be the participation on behalf of another, example client, at a public hearing or during an applicable comment period, or as opposed to a more conventional direct attempt to influence a government body or officer in person, digitally, or writing in relation to a pending decision relating to a development zoning outside of formality of a public hearing? Is there a difference?
Yes. So anything like public hearings in general, there's a lot of exclusions that I talked about at the very beginning that take an activity out of lobbying. So participation, generally speaking, participation in a public hearing would not be lobbying. There is, first of all, it's in the public, and it is those type of activities, participation in a public hearing, those have been excluded by the Lobbying Act itself. It sounded like the second part of that question was more the traditional lobbying that, people think of. So, I'd have to hear the facts again because it was a long question, but the beginning, public hearings in general, generally speaking, no, that's not lobbying. Participating in those are not. And it sounded like the second half of the question was a more traditional lobbying activity, and that could be.
Okay, great. We're going to let's do one more question. And this question is coming from Chris Wright. If you register as a lobbyist in 2020, but have no lobbying activities in 2021, do you have to re-register?
So the Lobbying Act requires biennial registrations. So every 2 years you register and it can count for the 2 years. So there was a new biennial that started this past January. So if there's a 2021 and 2022 biennial registration. And so if you register for a client back in 2020, you would have to re-register if it goes into 2021, because then you are between two biennial periods. But if you register, so that person would register again for the same client in 2021, and that would last 2 years, assuming that the contract lasts 2 years. Of course, the lobbying contract has start and end dates in it, but it can last up to 2 years within a biennial period.
Great, so that's our last question. Our last code for the day is blue, as in the color blue, BLUE. And I understand there were some questions on the second code. It was Prime, as in Amazon Prime, PRIME. So those are our second two codes. I gave the first code earlier. I cannot give this first code again. So thank you all for attending. To receive CLE credit again, you will receive a follow-up email similar to one you already had, with the information on how to submit your codes, how to submit your evaluation. All the materials that have been submitted in bios by the panel are included in that email for your own use. I want to thank all the panelists, especially our moderator, Carol, and Sanford, and everyone at the JCOPE for putting on this great presentation with the Center for City Law here at New York Law School. I want to thank everyone at New York Law School and our events team for putting this together, the staff of the City Law Center, again, on behalf of Professor Ross Sandler, Lillian Valley Santiago, Veronica Rose, and myself. We hope to see you at future events. The center's next CLE is actually coming right up on January 13th, property tax CLE. Please look forward to an invitation about that. And until then, we want to wish everyone a healthy, happy, and safe holiday season. And we look forward to seeing you all in the new year. So thank you all again, and have a great afternoon.
Thanks. Thank you.
Thank you.
Thank you again to New York Law School.